Hello, everyone. Welcome back to another Canadian Immigration Live Q&A. I am here with, as always, my co-host, Alicia, who is just about in a position now to take this over, which I'm really excited about. So I can keep working on my courses, which I've got a bunch that are coming out, everyone. So welcome to this live Q&A. It's kind of a one-of-a-kind thing here that we're doing, and we're hopeful that the people that are connecting in are getting benefit from this. If you have questions that you would like to ask us, by all means, post those in the comment section. We will get to those. Always remember to put a Q in front of them, because that is how we know you're not just chatting amongst yourselves in the feed, and which ones you want us to actually pull up and ask here on the feed. So I'm here with Alicia. How are you doing, Alicia?
I'm well. You know what? It's it's good to be an immigration lawyer sometimes. Sometimes you get good feedback from people, and I just had two really nice consults this morning and really genuine. And people, one of whom has been tuning into these videos and said that they appreciated it, and it's just really nice to connect with people and see the effects of what happens in the world when you give a little bit of information and how it actually really can change people's lives, hopefully for the better. So hopefully we're doing something here that's useful.
Yes, I hope so too. And just this morning as well, I had a consultation with a lady who lives in the UAE, and she said the same thing. You know, there's nothing more amazing than to have someone book a consult, and the first thing that they say when they connect in is "Thank you so much for all that you do." And I've
Yeah.
been following the channel for so long, and I've learned and studied everything that I can get my hands on, but I have these specific areas about my own personal situation that I need some advice on, and to be able to offer all of this and really amplify our message. You know, yesterday we did in the afternoon a special video. If you guys haven't watched it, we're struggling to figure out how to get this out to the world. So make sure you like and subscribe to our channel. Please do, and hit those notification bells when you see. And I'll just flip over here to the website. When you go to our channel, and you'll see that we try to do these in advance, so you can schedule them, and you can get a reminder, but make sure that you do that. But yesterday we did this one right here on the accelerated tech pathway, which was wonderful. And as far as the message goes, I think we had at a high maybe 40 to 50 people that were watching it, just maybe the time or whatever. But now it's already, you can see Alicia's already up to 1,300 people. So this is kind of what we try to do, is we try to provide these live streams and be able to answer listener questions, but at the same time make it accessible so that people who are just searching for answers on these topics, they can find it. We're, but at the same time, like, we're not paying anything for Google ads or Facebook or YouTube. So we rely on you guys to share this. And I think we're just about at a position where maybe we will start to promote this a little bit more. But if you see something that you like, please share it with people. Let them know about what we're doing, because we love working with, right now we have 58 people that have tuned in, that are watching live. And I know others will catch the wave and fill in. We'll probably end up somewhere a little over 100 that watch live, but it's 11 a.m. in the morning and people are working, right? And so the people, when they come home, then they see these videos. But if there's one thing we'd love is to have 1,500 people watching live. So anything that we can do to help and support and yeah, you guys in your immigration journey, absolutely. Okay, well, today we're going to try something a little bit different, a little bit new. And in the background, as immigration lawyers, we are always searching through the case law, making sure there isn't some change, looking to see if a decision in court, we can rely upon it in our submissions to better support and enhance what we do for our clients, and to just give them better advice, because what happens in the courts filters down to how officers treat applications, and even the expectations of what our clients need to do to meet those standards. So we're going to share a case today, and I'll flip over here, Alicia, and we'll let Alicia kind of drive the ship. But this is the case. Probortona, I think
Yeah.
is what it is, versus immigration, essentially. So maybe, Alicia, you can just give us a little bit of background on this.
Sure. So it's a recent decision. It's a December 2021, so just a couple months ago. And this is a decision of a refusal on an express entry application. So what happens, of course, is that if your express entry application is refused, there's no way to appeal it. And what you can do instead is file for judicial review to the federal court. So it's an application for leave to the judicial review process at federal court for immigration matters. And so this is always tricky because it's not an appeal as of right. So you don't automatically get your day in court. You actually have to have a convincing enough argument to be able to have leave given to you, which is also another word for permission to continue with your case. And so another judge had given leave or permission to continue, and then this case actually made its way to federal court. And in fact, the federal court sided with the applicant, sided with the person who was putting in that express entry application, and said, you know what? Your refusal wasn't fair. And the thing to consider with express entry judicial reviews is that it doesn't mean that that person gets landed as a PR and gets their case approved. If you win on judicial review at federal court, it means it goes back to a new officer to consider the evidence all over again, and they could refuse for a different reason. So just keep in mind that, this is a long journey if you go down that federal court judicial review process, but it's really good when people do go through with it because it gives
Yes.
us helpful interpretation for how the courts are holding immigration to account in terms of what's transparent, what's fair, what is immigration doing that, is a little bit not right. It doesn't
Mm,
actually inform the public properly so that people can understand what to put into their express entry applications and whether they're eligible for what category.
you bet. Another thing I want to point out, and this is another thing people have to take into consideration. This decision was December 22nd, 2021. And the actual refusal in the application was way back in October 9th of 2020.
Mhm.
So
Yeah.
people need to understand that it takes time. Like you can see here, it took over a year to get to this point. And when you're
Yeah.
in a world of express entry, there are times where, if possible, it does make sense to just resubmit and get back into the pool.
Mhm.
But as we've
Yeah.
seen, October the 9th, this was a federal skilled worker. December 23rd, I think it was, of 2020 was the last draw that we had. So especially for
Mhm.
people who are in FSW, or right now with the way the pandemic is still lingering, the delays and the volumes and the backlogs that are built up within express entry, if you do get a refusal, there is no telling when or if you will ever get an invitation to apply again. So especially
Mhm.
outlanders who were drawn in the days, and at this time October the 9th is when the refusal came. So this application was probably submitted early 2020, the actual submission itself. So there's a number of factors, but there's very, very good reason to consider challenging, because it may be your only kick at the can.
Yeah. And keep in mind too, there are time deadlines on this. So if you do get a refusal, you need to make sure to have a consult with a lawyer as soon as possible because if it's an in Canada refusal, you've got 15 days. If it's an outside Canada refusal, it's 60 days. So there are tight timelines for this, and those 60 days or 15 days, you've got to serve the Department of Justice with these documents, and that takes time because it's got to be physical service. So, make sure you give your lawyer enough time to review the case with you and actually start your federal court matter if that's where you're going with it.
You bet. All right. So maybe give us a little bit of facts here, Alicia.
So when you read the case law, it always starts with the facts. And so this is just setting up who's the applicant. The applicant's a citizen of Bangladesh, but is qualified as a lawyer in England and Wales. So in this case, working as a lawyer and had done this is all about education. And
Mhm.
if people have multiple degrees and they're trying to figure out how to enter and give themselves credit for those degrees, this case is for you. Take a look at this case because in this instance, she had a Bachelor of Laws in England and then a postgraduate diploma in professional legal skills that is going to allow her to complete her bar exams or actually get called to be able to practice. And those are what you need to be able to practice in England and Wales. And it's interesting because what happened was she went and got an ICAS. So if you look at your education credential assessment organizations, there are only some of them that are accredited by immigration, and she chose one of them. Well, when she went and got her education assessed, that came back as equivalent to a bachelor's degree and a post-bachelor's diploma, which is a little bit strange. So if it were me, if it were my client and they came back with this ICAS, I would have immediately said, let's go try another education credential assessment organization, and let's make sure that that education assessment comes back as equivalent to a master's degree or a degree required to practice in a professional occupation. Because lawyers, we have to meet a professional level of regulation. And so not everybody can work as a lawyer, and it's equivalent to a master's degree or something that you need for professional accreditation. And when you look at immigration's website, it lists specifically which occupations are required for meeting this professional accreditation standard. But I don't know what happened in her circumstance, but she went through with it. So she submitted that ICAS assessment, education credential assessment. And what happened then was she thought she had more points. So she had selected that she was equivalent to a master's, but immigration then substituted evaluation. So they went in and they looked at that education credential assessment and they said, no way, your education credential assessment doesn't support the fact that you selected a master's degree or professional degree needed to practice in a licensed profession. So they said, and the points were close, right? So
Mhm.
on her express entry profile, she thought she had a score of 481, but the lowest round for that July invitation was 478. And they said, too bad, your education credential assessment doesn't support what you claimed for your master's or professional degree. Therefore, we're going to bump you down and you're refused. End of story.
And it's interesting, Alicia, like when we look at this, and Alicia will get into more details, but the reason this is important for a couple reasons. One is that just because ICAS equates, in this case, like I don't know too many places where an individual could complete a law degree in the University of England, like in England, and not have that equate to the equivalent here in Canada. So there's like a little bit of a smell test, and I'm not sure exactly what happened. I don't know this De Montfort University. Maybe it was a really low grade school and it wasn't really the same, but she's practicing, right? She's practicing, or I think it's a she that is practicing in the in England as an actual barrister. So to have them come back and say, well, it's just a bachelor's degree. Many people would just assume, oh, post-bachelor diploma. Well, maybe that's what a professional is. But in this case, we see a lot of this happening in India with master's degrees, in particular MBAs and things like that are downgraded by WES. And then people will go to IQAS or one of these other ones, and then they will equate it as being equivalent to a master's. So yeah, first, just to reiterate again, you do not have to rely on one educational credential assessment agency if they don't give something that you feel you're entitled to. You can shop around a little bit. So, all right, Alicia, continue on here.
Yeah. So, and she had also said, when she looked on the website, when she goes to the education tables and looks at what her points assessments should be, she thought, okay, well, I'm properly selecting master's or equivalent professional licensing for that 126, for the 126 points. But immigration's system doesn't have an option. And this is where the judge sided with the
Mm-hmm.
applicant, because when you look at the drop-down menu selections in your express entry profile, it's different than what you look at when you look at the ranking. So maybe Mark, you can pull
Yeah,
this
let's
up
pull
and we
this
can.
up. So if we look at the let's see here. Let's go back here. This one, the calculator here. So this is the CRS scores. Let me
Mhm.
just pull this up one more time here. It's CRS tool. That should get us where we need to go. Yeah. So when
Mhm.
and I think this is kind of what she was looking at, right? So we'll just fill in a couple here till we get to it here. So this is what it asks when you're doing the calculator.
Yeah.
And so,
Yeah. So it says 2-year program at a university college, or it says 2 or more certificates, diplomas, or degrees. One must be for a program of 3 years or more. And then it also says master's degree or professional degree needed to practice in a licensed profession, see help. And when you look at that other table for the education, then it'll give you the equivalent scores.
this is zip down here. There we go.
Mhm. So the 2 or more certificates, diplomas, yeah. And I think, are those the applying with a spouse? Yeah.
Yeah,
So
that's the spouse on this side right here.
yeah. So this is where there was a disjunct. And then when you go into your express entry profile, the drop-down selections, it doesn't say 2 or more certificates. Each degree has to have a particular description. And so this is where she said, well, I put in my express entry profile in EAPR, I put each of those degrees was equivalent to a master's or professional level certification because I have to have them to practice as a lawyer. And the officer said, too bad, no, because your education credential assessment doesn't say that. I'm just refusing you outright. And the federal court judge said, well, that's not fair. It's not transparent because she had also submitted letters of employment and other proof that she was a practicing lawyer at the bar. And there was enough other evidence. So it's not just, an officer shouldn't just look at the first part of that says master's level, because it's not a master's level. It's a professional degree that's required to practice in a licensed profession. And that's what she was arguing, was that, no, I can't work as a lawyer unless I have this proper accreditation, and I'm clearly working as a lawyer, so there's my evidence. And the court sided with her and said, yeah, it's got to go back for redetermination and a new decision will be issued. And there's also reference to another case as well, and how they treated that case. And in the other case, it had to do with Wes and 2 degrees. But I guess the moral of the story is don't give up. So
Mm-hmm.
if you've had, first of all, in the first instance, if you do your education credential assessment and the first agency says, we don't think it's what you think it should be, then go get a second opinion, go take the time to do that. Another education credential assessment, some of the organizations you can kind of challenge their decision or talk with them to try to figure out why they gave you that designation. But if not, you can try a different organization. The second moral of the story is, if you have a solid argument and you put other supporting evidence in there to prove your education and your qualifications, and the officer ought to have taken that into account, then it's possible to have that argument stand at federal court.
Yeah. And I'm just going to, while you were doing that, the fun part of this is I can work quick, and I just built up a profile so that people could see the difference. So when you're working through these and answering the questions for the little wizard, the little tool that allows you to see whether or not you qualify or eligible to submit a profile. So like I said here, you're actually selecting what you think you have. I have this level, and this is where this is the level of education I'm going to have. When you go into your actual profile, you have the same ability. So you can indicate here, whatever the field that you're in, since whatever, this is my current study, yes, completed full academic years, standing, country, name of school, level of education. And so this right here is where you indicate what you think you have. And so when you enter it in, I'm not sure, she must have just entered in master's here and then gone forward from there. And that's really where the distinction is, I guess, because it doesn't, there isn't an option when you're filling out your education history to choose masters or professionals as the category that you feel you should get your points in. The system, if it sees that you've got a bachelor's and not a master's plus maybe 2 bachelors, it will automatically award you those lower points. But if you manually choose, like you can, even though your ECA says something different, you can choose masters regardless, put it in here. And this is the crazy thing about this decision. When I look at it on its surface, yes, it's clear she made a mistake when she was entering this. But the reality is the court actually sided with her when I believe the officer wasn't wrong in a strict interpretation, because the educational credential assessment didn't say master's or professional. So that's the thing that's why this case, you guys, is so important, because the officer, if I was to review it and how they apply strictly, the whole reason that they do ECAs and require candidates to do an educational credential assessment is so that the officers don't have to think and to evaluate and look at the work history and say, is that enough to be considered a lawyer? They just look at on the face of the ECA. And if it says it was equated to a graduate diploma, then, well, that's 2 or more credentials, not masters. So yeah, so I'll turn it back to you, but that's a thing that was just the most mind-boggling to me when we were looking at this case.
Yeah. And I think it's because the judge didn't believe that the way that immigration had set up the selection process, their public-facing information didn't
Yep.
seem fair. And that's why they granted them the judicial review and they said, okay, it's got to go back to another officer for redetermination. But overall, you don't want to be in this situation where
No.
you have to wait another year and fight it all the way through to court. You want to make sure that you get that proper education credential assessment from the beginning, and that you make sure that you're entering in clearly what your education is. And if there's any nuances in that, you've got a very good letter of explanation describing your education.
Yeah. So pay attention to this, you guys. Check out this case. An easy way to search for it is just to use the citation. You can just Google 2021 Federal Court 1461 and you can pull it up yourself and read all the details on it. But I think that kind of covers things off, Alicia. Is there anything else that you wanted to add in? Any other caveats or anything like that?
Well, I mean, each case depends on its facts, and I always say that too, right? So each of these cases, it's like a little snapshot for somebody's trajectory and life history, and you can apply the concepts of this case sometimes, but they're going to distinguish this case if your circumstances are sufficiently different. So, try to do it right the first time instead of having to argue after the fact for why you can save it.
Yeah, exactly. And then remember, on Tuesday of next week, after Valentine's Day on Monday, because that's the day I'm spending with my wife, we are starting the next master class, February the 15th to the 19th, which is Saturday morning inclusive. And that's 5 to 6 p.m. Mountain Time, the Express Entry course. So all of you who received notifications of interest from the OINP or the AINP, or any province really, that are going to be able to go through the express entry process right now because you've got that nomination, it's a perfect time to take the course, join it with me, and you can go right in here. Though there's a link in the description, and it's going to be wonderful. It's going to be awesome. It always is. So consider subscribing and joining us. And there's already some people over waiting in the Facebook group that have registered, and you're going to get access to the course material right away. So I just wanted to give everybody a heads up about that. Okay, shall we see who's checked in with us here, Alicia? So let's see who we've got here. Okay, we'll get this lined up. So we've got Rizal is here, and of course, Chaitanya, always doing good, my friend. We've got Yun Chen. Hello from Edmonton. Good to see you. Jay's tuning in. Lainel is in Kuwait. Wow, awesome. We're doing great, Chaitanya. And good morning to you, Bright. Good to see you. Bright was also attending the session yesterday afternoon on the Alberta tech stream. So that's cool. Budika, good to see you. And like I said, if you have questions, we'll get to those in just a second here. Always remember to put a Q in front of it. So Aisha is saying hello, and we've got Tahara there. And and there's the Sura. He says, I was able to submit my EAPR just 2 days after receiving my ITA. I had all my documents ready thanks to your masterclass. Thank you so much for everything you and your team does. Thank you so much, Thesura. I appreciate that. So what he's talking about is he took the course before he got his ITA. So, and many of you are in that situation. And that's one of the things that I love most, when people take it well in advance so that they're not rushed. They've got time to absorb everything. And then when the time comes to get the ITA, they've got everything in place, and it's just a matter of loading it in and submitting it. And so, Thesura, thank you so much for that shout out. Very, very kind. Okay, let's see. Muhammad is over in Pakistan. I love it. He's got the flag there. Very cool. And we've got Irfan, who's also been a frequent follower. Hello to you. It's nice to see similar faces and similar names here as we're pulling this up. And then it looks like we have someone who's actually watching from the Express Entry Law private Facebook group. And so when your name and profile are kind of generic, that's usually how it is. So excellent. Okay. Faith says, I hope you feel better, Mark. I'm feeling a lot better. Tonight I'm going to meet the family of my friend, and it'll be nice to see them and spend some time with them. And then the funeral's tomorrow. So you can watch the live yesterday if you want to feel sad and feel tears. So we'll let that one continue on. Okay. From Nairobi, Kenya. Excellent. Good to have you. And okay. So Jansen says, dear someone, scam with Pakistan. You guys are posting comments that are in different languages. I have no clue what that means, but we'll leave it the way it is. All right. Let's see. Who else do we have here? Let's see. We'll do a couple more shout outs and then we'll get in there. So Carlos Centeno, good evening to you. And let's see here. I think we've gone through quite a bit. So what we'll do is I'm gonna scroll down here a little bit further. Ahmed, hello, good to see you. We've got Eric, who's watching from the Kingdom of Saudi Arabia. Waleed, hello to you. And like I said, if you have questions, hold off on them just for now, and then we'll jump into them. Andy, good to see you. Greetings, he says, from Ottawa. And I think, Andy, I think you joined us last night as well. So, and then there's a shout out specifically to Alicia. All right. And thank you, Waleed. I appreciate that. And then Anita, and well, hello to you and Ida, and everybody's now posting where they're tuning in from. So we've got Manashresh, who's in Ottawa as well. All right. So starting now, go ahead and post your questions. Remember to put a Q in front of it, and then we will make sure that we address the questions and that they don't get missed. Okay. Yes. Andy says, yes, he did. And it's good to see you. We've got Herb, who's over in Halifax. Very cool. All right. So yeah, post your questions and make sure to put a Q in front of them. Now everybody's giving you shout outs, Alicia. So
Thanks, everybody.
This is not the Mark show. This is the Alicia show. Okay. Here's the first one from Gunnar Boy. Nice. He says, hey, Mark, I know that you had a chat with the minister. What are the odds of another temporary policy for extension of Post-Grad based off the interview? Thanks in advance. So not only did we have the meeting as table officers with the Canadian Bar Association with the minister, but we also formed a working group very quickly, and some amazing lawyers within our section held the pen on it to draft the initial submission. And then I think there were about 8 of us that were responding and involved with that initial one. It was all about this, requesting to the minister that they redo the temporary policy to allow for additional post-grad work permits to be issued to people in specific parameters. So ultimately, I think in my mind, that's the solution that the minister, I think, has to consider. Otherwise, many people are simply going to fall out of status. And personally, it's going to create way more work for the department than if they just open up the 18-month policy. Because one thing as a law firm we will do is we will look at all kinds of different applications, TRPs, you name it, to try to keep people, both in status and otherwise. And so by creating it, I think it's actually going to allow for a more streamlined, managed process forward through this pause within Express Entry. But I don't know your thoughts, Alicia. What do you think about this situation?
Yeah, I mean, I really hope they do grant another temporary public policy for people who have been working, they've graduated from school, they are maintaining their status, they're doing everything they can to, survive in this drought of express entry nominations. And so some people are going through and getting the PNP nominations, and that's great, that's fantastic. But if you're not able to get a PNP nomination, and let's face it, some provinces, it's really tough depending on what occupation you're working in. So make sure that you're looking and keeping an eye on what's happening with other options. And it's hopeful that they are going to do something to try to help people who have had or are on post-grad work permits and need to extend their status.
Yeah. All right. Raghu says, is it totally safe to decline an ITA because of delays in a police clearance certificate? I got BC Pnp nomination in January, first week, and is valid for 180 days. So here's the thing. We expect that the PNP rounds of invitations will continue. We expect that they will. But the challenge that you have is obviously you need that police certificate when you file your EAPR. And so the risk is if you go ahead and you try to provide evidence that you've requested it, that an officer is just going to go back to the cruel world that they used to have, which is no mercy. And, but there is a reality that if you decline the ITA, your nomination needs to remain valid. And usually they're about 6 months. And you are exposed potentially to whether or not they're going to do another Pnp draw. But Alicia, I don't know what your thoughts are on this, but I think if I was looking at the odds, and sometimes that's what we look at, is it more likely or less likely that immigration is going to do another Pnp draw? Well, I think it's highly likely, especially given my discussion with the minister and with what we've seen and their commitments to the provinces to continue issuing these rounds of invitations. I think that the risk of declining the ITA, going back into the pool, is less, and not seeing another one. I think that risk of not seeing another ITA before your PNP nomination expires is less than submitting an application without the police certificate and hoping that an officer will let you correct it and update it once you get it. But boy, it's, either way carries its risks.
Yeah, I mean, the other thing is maybe you can talk with the BC PNP to see if they will extend that nomination as well. Some PNPs will do it, others won't. So we just did the AINP presentation yesterday, and one of the things to note that we didn't even talk about yesterday, but they specifically say through the AINP for Alberta, we will not extend those nominations at all for the AINP express entry stream. But some provincial nominees or provinces will actually extend that provincial nominee nominations. So maybe that's another tactic, is to try to reach out to them and say, look, here's what happened, here's my situation, and see if they will extend your nomination.
You bet. Yeah, that's really good advice. Andy, as far as the case for that case law, like I said, you can easily search through CanLII, that citation that we showed. But yeah, after this video, I'll put a link to it in the show notes so that you can go back and you can check out that case yourself as well. Okay. All right. Now I'm trying to scroll back down to where I saw the very first Q question. This is the challenge when we have so many people that are posting questions. So I think I'm going to start right here. I'm not sure where it is. So we'll go to Noah. So for express entry, is there any minimum wage regarding occupations? For example, management job or B-skilled job with minimum wage in provinces. Is it okay to pass, or is it going to be a problem for an application? This is a great question, actually.
Yeah, and we get this question a number of times in different kind of incarnations, depending on which application category you're applying under. So for express entry alone, if you're doing, I'm assuming you're doing a CEC application. If you're looking at minimum wage in the province, I'm assuming you're inland. But for those express entry applications, you just have to be paid a wage, and it doesn't specify federally whether that wage has to meet a certain, median wage rate or anything else. But you do have to make sure that if you are in a management level job, for example, if you've claimed a NOC where you have, senior authority, your manager, you've got a whole bunch of people reporting to you, and you're making minimum wage, you're making $15 an hour, an officer might very well question, well, wait a minute, do you actually have a managerial level position? And so that's where the problem comes in.
And yeah, and you think about it too. Like lots of times people will come to us, and I've seen it happen repeatedly. They're on an LMIA based work permit, and they've got a job offer and they have all of these things. But when we look at the pay slips and the pay stubs, they're not being paid what the LMIA said they were supposed to be paid. And when you're filing applications in that context, it is possible that those things can come back and bite you on the PR side. But the reality is the employer is offside when it comes
Mhm.
to their LMIA, which can expose them to monetary penalties or fines. AMPs and bans, we call them, administrative monetary penalties. So you have to be really, really careful. And you can't just rely on your employer and just trust them. You need to understand what's going on with your situation, including the details of your labor market impact assessment. And if you're working on that type of a work permit, there are hours too that are
Yeah.
restricted and overtime. And lots
Yeah.
of people just kind of gloss over that when their employer says, hey, can you work another double shift because someone can't come in? And of course, you're an awesome employee because you international, foreign workers are. You think, well, hey, they'll support my PR if I do that. Well, that's fine, but they have an obligation to pay you overtime or as it's set out in your contract. So definitely be aware of that.
Yeah, and along those lines too, Mark, one of the things that we saw a lot of in the TR to PR stream was students who were working part-time. And this became a problem because, there was a public policy for certain industries to be able to work more than the regular
Mm-hmm.
hours. But for a lot of students, you're only authorized to work 20 hours a week when you're studying full-time under the terms of your study permit. And people then were trying to claim that they were working because maybe an employer asked them to work extra shifts or other people were sick. And then now they've gotten into a situation where they had illegal work, which you then need to declare on your PR application. So Noah, for your question, make sure that there is a difference between what kind of work permit you're working on. So if you have an open postgrad work permit or a different type of open work permit, then technically, no, you don't have to meet a minimum wage, but your wage needs to make sense with the
Mm-hmm.
occupation that you picked for your knock for that code. The next thing is if you do have an LMIA, if you're working on a labor market impact assessment, employer specific work permit, then your wage should meet what your employer put on that LMIA application. Also, though, take note that the employer, when they're doing that LMIA application, they certify that every year they'll go in and they'll review your wages. And so if what's happened is the median wage rate has gone up over the last year, let's say you've been working there for a year, then they're actually supposed to pay you more, and they can justify that increase in the payment based on what the median posted wage rate has increased to.
Mm-hmm.
So,
Excellent. Okay. Next question is from Joseph. He says, hello, Mark and Alicia. Can we apply for a work permit from a country other than our country of residence because the processing times are faster? So scenario 2, and I'm not sure what scenario 1 is, but will the situation change if we have citizenship in both of those countries? So one thing I guess I'll start out with as you think about the answer to this, the government, like IRCC, with all of these online applications, they can shift the processing to anywhere within the global network. And I talked a little bit about it yesterday. We've seen permanent resident applications, spousal sponsorships being processed for Americans in, Mexico City. But at the end of the day, if there's a passport request, then that will need to go through where you are residing, obviously, and the VAC that is associated with that. But Alicia, what do you think about this
yeah, and
strategy, right?
it's interesting because I mean I'd have to pop back over to the regulations on place of application because they have changed them and updated them. But it used to be that you had to submit an application in the place where you were residing or you had citizenship. And
Mhm.
so sometimes people would say, well, wait, I've got citizenship somewhere, but I'm residing somewhere else, and they'll put in that application because they know there's faster processing times.
Yeah.
But you then will have to travel to wherever you need to go to get that passport visa issuance. So that's one thing to consider. If you've got citizenship of both countries, then theoretically, yes, you could submit the application. With the online world now, it's a little bit different because there's no physical application package that's going out. And usually they're sending you that confirmation letter electronically, depending on whether you need to actually submit a physical passport for it or not.
Mhm.
So um, be careful, check what the regulations are saying on place of application for your type of work permit. And if you're authorized to be able to do that and if you can travel. I know sometimes people had problems because during the pandemic, they weren't actually able to get out to travel where they needed to go to, where their application was in process, or they had to go do biometrics and there were no biometrics facilities that were open in their country of residence. So take a look and see, make sure to kind of think it through to the end.
Yeah. I have to post that one, Alicia. So Anushka, she says you've got a nice smile. So that's great. Okay. Pernendu says, thanks again for the time. Love from Assam, India. Could you tell impact of EEFSW profile on student visa approvals? As we mentioned in university applications, SOP to return back to home country. So we've talked a lot about this. This is a reality, you guys. So what are your thoughts on this one, Alicia?
Yeah. So you're allowed to have a dual intent. You're allowed to pursue a study permit application and also have an express entry profile sitting in the pool. However, the practical ramification of that is instantly you're going to have to prove strong ties to your home country. You're going to have to convince the officer who's looking at your study permit application that you're likely to go back to your home country at the end of your study permit. And if there are too many factors that seem to indicate that you're going to be trying to stay in Canada and do that express entry application instead, then it's possible that they may not approve your study permit for lack of ties.
This is a wild one. And yeah, it's a wild one. Okay. Sangini says, hey, Mark and Alicia, I am always waiting for the live sessions. I was hoping if we had any new CEC news or post-grad work permit extension since my permit has expired.
Uh-oh.
That is a tough one, Sangini. In all honesty, I don't know if you've received any advice or direction, but I would highly recommend, and if I don't even know if I guess I've got the triangle here. I'll ring that one, that you consider booking a consultation with us. Because yeah, falling out of status is really not something that you want to be in. And I'm not sure if you've taken steps to try to address that or what it is, but definitely I would highly encourage that you head over to our website and consider booking a consultation, because there might be some things that we can do to try to help, but the longer you are out of status, the more likelihood it is that the damage that you're causing being out of status is going to be irreparable, and you're not going to be able to fix it.
Yeah, keep in mind that there's a 90-day restoration period. So whenever your permit had expired, you've got 90 days from that to file that restoration application if you have fallen out of status. Make sure that you look at that carefully. You're clicking the restore plus whatever other application category you're eligible for, and you've got to submit an extra $200 fee to the government. And if you forget to do that, that restoration application might be lost. So because the processing times are so long, it takes them so long to open up those applications. So please book a consult and hopefully we can get some more details about your situation.
You bet. Nordine says, always you give us hope, Mark, to keep trying to survive. And, anything that we can do to try to help you guys and to share whatever knowledge or insight that we have, we will definitely do it. Okay, Darshan says, is it mandatory to show work experience which can't be claimed filing CEC?
Yes, yeah, it is. But you're going to want to put it in your personal history instead of claiming it for work experience points. So you guys can choose, right? If you are meeting your minimum eligibility requirements or however many years of foreign work experience that you can honestly show with backup documentation from your employer in terms of letters, pay stubs, tax documentation, great. But if you can't prove it and you know you can't prove it and you're not needing to rely on it for points, then just put it in your personal history, because you want to make sure that you're being honest and accounting for what you've been doing with your life without missing any month. They want every single month accounted for.
Yep. Okay, Ida says, I have an enrollment at the Toronto School of Management, but I'm scared to apply, though my brother wants to sponsor me. So I think this one, Ida, I'm going to ring the bell again and tell you to slide over and book a consult so that we can talk you through it. Obviously, a big component of this is financial. And when you have siblings in Canada, it can be an advantage and it can be a disadvantage too. And the source of the funds and all of those things. It's become extremely complex filing study permit applications now. And it's so specific to you. There is no boilerplate. If you do this, your application is going to get approved, even if that is following everything that the document checklist tells you to do. There are so many things now that we find we need to add on based on your specific circumstances to increase or at least give you a chance of success. So there's a lot of different things, moving parts here. And, part of the reason we do those consults is to remove the fear. And why are people scared? It's the unknown. And that's really what we try to do, is to address that so that you understand the facts and then you can make decisions. So I recommend you slide over and book that consult. Okay, let's see what's next here. Okay, SJ says, what will happen to the startup visa paper application submitted at Nova Scotia? Got the temporary file number as of now. I can maybe jump onto this one, Alicia. All across the country, whether it's the PNPs or whether it's the federal program, the startup, all of these startup visas, the processing times are off the charts. And I think one projection I think we saw with the government was that it was going to be, anywhere from 3 to 5 years for them to get through this backlog. And so what you can expect is a very, very, very long wait. And in the process of doing that, I would keep all of your other options open as much as you can. If you got an express entry profile, keep that in, whatever it takes. That's what I would recommend. All right. And this is a good prompt for me to get LJ back on to talk about this, but UAE has a very high refusal rate for study permit applications. Any advice on how we can strengthen our application given that our status in the country is only temporary?
Yeah. And this is a really hard one because I've talked with a lot of people who are working temporarily in the Middle East, but they are nationals of a different country, right? They're from India or the Philippines or Pakistan, and they are working in the UAE, or sometimes they're working in Saudi Arabia. So, you know, making sure that you have a very strong connection to your home country, whatever your home country of nationality is. And in the Middle East, sometimes they will allow you, maybe if you've even been born there. I've had clients who were born in the Middle East and were living there their entire lives, but they just keep renewing their temporary status, and that's all that's available to them. But when you're not a citizen of one of those countries, the default reaction that I've seen from refusals that people are bringing is that the officer says you can't prove that you have the ability to return to the Middle East. And it's very difficult because you have to prove ties to your home country. And so they'll look at all sorts of things. They'll look at your property there, they'll look at your work history, they'll look at where all your family members are. But if you don't have anything legally showing that there's a good chance that you can come back or what your pathway to returning there would be, it's going to be an uphill battle for sure.
Yes. And sometimes if your circumstances are such, you may have a spouse that's not coming with you. And maybe this spouse is the principal in the UAE, and you are dependent. And so there's no problems with returning because you still have that anchor. But ultimately, yeah, when you're on your own, unless you have an employer who has that job offer and says, if Katrizia goes to Canada and studies, we've got this job waiting for her when she comes back, and we will continue to sponsor her visa and she can easily return. Those things can help, but even in and of themselves, there's still not a guarantee that the officers are going to accept that. So yeah. I want to give a big thank you to Gooner Boy here. We answered his question, but thank you for that super chat. Thanks for answering my question, he says, about the post-grad work permit extensions. It's hard not knowing what the future holds, and thanks for fighting this battle for us. Well, you know what? And in many respects, Alicia, that's what I feel. I feel like all of the people, all of this big collective family we have within the Canadian Immigration Institute, when I'm speaking to the minister or I'm attending government meetings, and even in the next couple of weeks, we're going to have a special pain points call with IRCC and the other representative organizations to discuss some of the challenges. Like, trust me, these are the things that we talk about. The last thing, what I don't do is go and say, well, I have a client, Gunnar, and he has this situation, and I want you to tell me how to fix it. Like that case specific stuff is not what we do. It would be completely inappropriate to leverage the position, my position for my own personal practice. But I can tell you what we learn from these live Q&As is these massive trends that are happening. People that are running out, consistently running out of time on their work permits. And we see this big wave coming. And because of you, before the wave actually comes. So we see that initial, tsunami, the water kind of pulling back. We can start to see that through these live Q&As because of the questions that you ask. And then that, we feel our purpose and our priority is to make sure that we're advocating on your behalf. And I think, the vast majority of the lawyers that are a part of the Canadian Bar Association, we are always we're thinking of you. We're thinking of the people that aren't our clients and the overall large scale impacts of the decisions that immigration is making, including suspending the ITAs. So yeah, just something to, I guess, to kind of think about.
Just to add to this, and the Canadian Bar Association, it's a volunteer organization.
Yeah.
This is just lawyers who are taking their personal time to try to advocate on behalf of the profession and to make the system better. And there's no, it's sometimes a thankless job. Mark, I don't know how many hundreds of hours you have put in as the chair for the CBA last year, and you're the immediate past chair right now. So kudos to you because it is a labor of love. So good on you.
Yeah. And that's, kind comments like this. And that's what feeds me, right? That's what causes you to want to keep doing this. Okay. Boudica says, can you please let me know whether I can use the Canadian Post-Grad credentials for citizenship language requirement? So that's a good question. I'm not sure. I don't have an answer for that one, Alicia. Maybe this is
Yeah,
something we'll have to take back. I haven't
we'd
looked.
have to look it up. I
Yeah.
haven't looked it up to see if they will accept that on the
Mhm.
citizenship.
Yeah. It's interesting when it comes for language requirements, when they're asking for tests, the validity of those exams are still 2 years. That doesn't change. And so, when in doubt, I always will just go ahead and redo it. If there's any doubt or any question, and understand that there's a lot of new officers, and sometimes officers make mistakes too. And so, I always will side on, I would take the side of a cautionary approach, Boudica. And if there is any doubt, I would just, redo the exam if it's required versus relying on a past one.
Yeah.
Okay. Well, Lead is asking a very open-ended question. Maybe you can give the Coles Notes version on intercompany transfer work permits here, Alicia.
Yeah, sure. Okay, intercompany transfer work permits. It's going to depend on the country of your nationality and which free trade agreement applies to you. So there are generally um, requirements that are in common for intercompany transfers, but there are specifics for certain countries. So be careful about which country you're applying from and make sure to follow the rules that are set out specifically for that free trade agreement. For intercompany transfers, usually you have to have proven that you've been working there for at least 1 year in the same occupation that your company wants to transfer you to in a related organization within their Canadian operations. So there has to be some sort of affiliate relationship between the foreign company and the Canadian company. And you have to have proven that you've been working there for usually at least 1 year in the same role. So the same knock, the same job description and duties. And then you're going to be coming and doing that same job also in Canada. So those are things that are super important. Also, you also can't be there's specialized knowledge requirements or managerial level requirements. So it can't just be any type of job. And they get very specific about what that means in terms of what's specialized knowledge and what's a managerial level. So be careful about that as well.
Yeah. And when you think about specialized knowledge, something that is, it's at an advanced level that is in many respects, almost proprietary to the company. It's a level of knowledge that's idiosyncratic to what the company does. And we see that depending on the country that you're coming from, the standard of what constitutes specialized knowledge for India, let's say, compared to what it would be for an American coming up from the US is different. And so, they have different standards, and you have to be aware of that as well. Okay, Yoshi has got an application in the queue, November 2020, biometrics, March 21st of 2021. Background in process, got a job, postdoctoral scientist. Desperately need to get to work. Do I wait for the passport request or apply for a work permit? Stay safe. So November 2020. So one thing we do know, and you guys can see what's happening, and this is another example of the water kind of drawing back from the beach with the wave coming. We're starting to see a lot more signs now of people getting those passport requests. And we're starting to see a lot more movement, and IRCC is really pushing forward now to try to deal with this backlog. And the minister indicated that they were really trying to get through the backlog before mid-year. And so it's a tough one. Ultimately, there's nothing stopping you. And I'll turn it over to Alicia. There's nothing stopping you from applying.
Mm-hmm. Yeah, it depends on your country of nationality because we're looking at those processing times. Like for India, I think they were at 51 weeks in processing time for an overseas work permit, which is just brutal. Like that's that's a year. But if that's the only option and if it's a reasonable option for you to put in that work permit application because your employer is willing to support it and they need you to get to work right away, then there's no harm in doing that. You may have to, it's 53 weeks now, so it's over a year now. So it depends on country of nationality, but it's a long processing time right now.
Yeah. All right. Next question is from Mohammed. And he says, if I get my PR app approved while I'm studying as an international student, can I then stop my program and have legal status?
So, okay. So only people who are foreign nationals, meaning they're not a citizen of Canada or they're not a permanent resident of Canada or somebody who has status under the Indian Act of Canada, only people who are foreign nationals require a study permit, a work permit, or visitor status. Once you're a landed permanent resident, then you don't have to have another document in order to be able to maintain your status. But just be careful because if you're not quite finished your PR yet and you decide somehow to stop your studies ahead of time, then you're in breach of the conditions of your study permit as soon as you're no longer actively pursuing studies. And this is something that I think a lot of people are running into, that something's happened, they've had some mental health issues, they've had some health issues maybe, they've had COVID or long COVID, and they're taking extended leaves of absence from school. And be really careful because after 150 days, you have to make sure that you've gotten that leave of absence properly approved. And if it goes past 150 days, it's no longer an authorized leave of absence. So people are then not able to get their postgraduate work permits approved, and then they're running into big problems because now they have to leave. So just be
Yeah.
really careful and make sure that you have your COPR in hand
Yes.
there.
Yeah. We'll hit a couple more questions and then we're going to wrap up for today. This one, I'm going to ring the bell right off the top, but I will acknowledge it. It's a little bit complicated. So once again, work permits, and we've seen right here, the delays in processing are off the charts here in some countries. So 53 weeks. And the question is, okay, we applied. Now my husband has been able to go get a visitor visa. Can he go down to the border and do a loop around the pole, essentially? But the LMIA validity is expired, and the permanent residence has applied through Alberta Pnp. I know where this is going, and even if every circumstance in the world was perfect for you and there was no other issues, never ever go down to the border in Alberta. I could see just all kinds of horrific things happening, including, oh, you're here on a visitor visa. Well, let me see your phone. And then on the phone, it shows that your husband maybe has started work a little bit earlier for this company in Alberta because lots of them don't care about you. They just want you to work as fast as possible, and we won't say anything and we'll hold your pay. All of that stuff, the officers have devious ways of dragging it out of people. And even if there isn't evidence, I've seen them say, come on, I know you've worked illegally. And then they just say, I'm going to return you back. I'm going to give you an allowed to leave. I'm going to give you a deferral of examination, pack up your stuff and hit the road, and don't come back until your work permit is approved. And in some cases, if they do find unauthorized work, it can unravel everything. So this is,
Because then they can find you inadmissible for breach of the act.
Yeah,
This
absolutely.
is, yeah.
Yep.
Please book a consult.
Yes, definitely. And we'll wrap up with this kind of tricky one. So AOR August 2020, medical is still under process. Through GCMS, came to know there is M5 inadmissibility. Application is still under process. No decision yet. What is the process ahead? Well, if you haven't received anything from them, and there is an escalated possibility that there could be a finding of medical inadmissibility, likely the next step is going to be a fairness letter. But Alicia, obviously we know nothing about the condition or anything like that, what's causing the M5, but what are your thoughts on this one?
So medical inadmissibility is a big bad area. So you're going to want to really get your ducks in a row in terms of going back and figuring out what's happening, and then getting really solid legal advice on how to move forward. Because depending on your medical condition and the medical evidence that you have, it's sometimes possible to refute this medical inadmissibility. So medical inadmissibility has changed quite a bit over the years in terms of the definition. There's been some cases that were very influential in overturning what constituted medical inadmissibility and what can be counted in their calculations for medical inadmissibility. It all comes down to this calculation of excessive demand. And so they're saying, we are going to find people who are foreign nationals, who are not Canadians, inadmissible. We're not going to let them into Canada if the cost of their care would be a certain number of times over the average cost for Canadian care. And so it's a very complex area, but you are going to want to have a solid evidentiary basis ready before they come to you with a fairness letter so that you can respond to their evidence.
Excellent. All right. I'm going to finish with the last one from Sunny here. His question is, his criminality is expiring soon as per GCMS. I'm not quite sure what that means, but should I send upfront police certificates? I think he means his police certificates are expiring, I guess. So should I send upfront police certificate? By the way, remeds, the background declaration, 5694 requested last month. Any hope? So
yeah, I mean, you might as well, right? Like if it seems like the criminalities or the police certificates are expiring, then you might as well send them another police certificate, just have that updated. And if they've already requested more information, hopefully you've already sent it to them, or you will do so before the timeline, then great, they should have everything they need, and hopefully you'll be processed.
Yes. Excellent. All right, everybody, we're going to end it there. And we've got a lot of people that are talking about saying they've asked the same question 100 times over. And and I want to apologize to everyone. We literally cannot answer everyone's question. So we'll go one more here, because I hate the fact people say they've come multiple times and not get their questions answered. But as always, remember, if you don't have your question answered and you can't get in, this is where you go and book a consultation with us. And obviously the super chats, we prioritize those within here, but let's just address Adam's very, very quick here. So he says, please, what are the eligibility criteria for a student visa? And do you think the visa officer reads the statement of Permis and LOE attached to the applications, especially when it's too long but detailed? So what Adam's getting to here is the Chinook system and whether or not they actually look at everything. And ultimately, they have an obligation to assess all of the information in the file. And if they don't, then that's a reviewable error. And so they can rely on Chinook all they want, but at the end of the day, if it's clearly evident that they have disregarded or ignored very important information that goes to the heart of the application, then that's a reviewable error and something that you can challenge them in federal court. But Alicia, as far as eligibility criteria, that's a big open thing, and I'll ring the bell here and I'll stop the music, but do you want to wrap up with this one? And this will be the last question we answer today.
Well, all right. So what I'll do, everybody, is I'm going to do a little quick blog article on top 5 reasons your study permits get refused. And I'll go through some of the basically the flags or things that, cause officers, or what I think would cause officers to say, there's a gap here, there's a good reason that I'm going to refuse this application, as an easy way to say lack of temporary intent. And there's some things that have come up over and over and again when I'm looking at why people have been refused on their study permit applications. In terms of why you get approved, make sure it all makes sense. So there is another case that was about study permits, and it specifically was asking about, is there a logical connection between your program of studies and your past history, your education, your career, everything else? And in that case, they had put forward a good argument about why it made logical sense for them. The officer didn't really consider it, they refused it, and they won at federal court. And that case is GEGA, GEGA versus Canada, and the citation is 2001 FC 1468. So
maybe we'll stick that one in the description here as well.
Yeah. So there are certain things to think about in terms of logically connecting your reason for studies.
Excellent. Okay, we are going to wrap this up. This could go on forever and ever, and you can see we love being here. We love chatting with all of you, and we hope that this is beneficial. I'll be back next Wednesday, but I can guarantee I'm going to be doing a video probably tomorrow on Express Entry, and it will be my top 3 tips for basically getting your, well, not top 3 tips, but the top 3 reasons most common that I see Express Entry applications getting rejected. And I'm going to share a ton of intel, specific stuff that I pull out from the course. So watch for that. I'm probably going to do it tomorrow afternoon or tomorrow evening. It just depends. And that's all a precursor, you guys, to the course that is launched again. So if you are thinking in any way, shape, or form of going through Express Entry at any time in the future, this course will give you the tools you need to prepare now. And within our new landing page, you can go through here and you can see actually how the course is set up. So there's a ton here. It's perfect for anyone, whether you're an immigration consultant, whether you're someone who knows nothing about Express Entry. It's all there for you. And ultimately, as we go through here, you can see we've got a structure of the course. So it talks about every single lesson, what's contained in the modules, and you guys can see for yourself. It is loaded. I've had 5 years, 6 years, however long to get this right. So, all right, Alicia, thanks for joining me, and we'll see you next week.
Thanks so much, Mark.
Take care.